This is Danielle Beach, and I'm here with Rachel Ullman and John Green, and they are going to be presenting today on prosecutorial discretion. Prosecutorial discretion is a term that is used both legally and not legally, and it's very broad. So there's been a lot happening on this lately. First of all, most of the memos that have come out have reversed the Tracy Short memo from 2017, and we're all very, very grateful for that. And then we have all these things that have happened since January. So in May 27, 2021, we had two very important memos that came out, the John Trevino and also the DHS Secretary David Pekoski. So both those came out on the same day and basically rescinded other existing policy memos that had been in the previous administration. So it looks like the government is willing now to do things which they were not previously willing to do. So we are looking for ways that we can explain to you and help you to do this so that you can take advantage for your clients and get prosecutorial discretion. So just a couple words about John Green. He is now in San Diego and enjoying fruit farming with his peach trees and lemon trees. And not only that, but he does some extreme sport things such as zip lining and riding bicycles down a volcano in Maui. Rachel is also an adventurer. She has bicycled twice across Iowa. So I think all three of us are into some kind of extreme sports. Myself, I'm into the skiing all over, wherever I can ski. So we want to approach this in an adventuresome way, but a careful way and thoughtful way so that we can give you tips as to what you can do and maybe what you might not want to do. So let me talk to John. When can you use PD?
Thank you, Danielle, for asking me that question. And everybody who's on this call, after we're done, I want you to contact every immigration lawyer you know, because the 100,000 people who've done immigration cases out there need to hear what I'm about to say. What cases can you ask for prosecutorial discretion? The answer is all of them. That's right, all of them. Because something really special and important happened on Monday that affects our presentation today. On Monday, Attorney General Merrick Garland vacated the decision of matter of ACAA, which is a prior decision from the last administration, which the Attorney General said that immigration courts cannot accept stipulations by the Department of Homeland Security and Immigration Court to any part of any case without independently determining that the basis was valid. So when the BIA would review a case, they had to say, well, look, anything stipulated doesn't count. Matter of ACA is now vacated, which means that the Office of Chief Counsel can stipulate to anything it wants to in immigration court, and that is valid and binding in the immigration court. The immigration judge can rely on that. So in every case that you have now in the immigration court, you can ask for prosecutorial discretion, and as part of that discretion, you can ask the Office of Chief Counsel to stipulate to whatever facts or law or benefits or relief that you think your client is entitled to, that you are seeking, and not just current cases. You can go back to cases with removal orders and voluntary departure for people who are still here in the United States or who've been wrongly removed. And you can ask Office of Chief Counsel to agree to reopen those cases. Every case you ever had, and every case you currently have. Everything, all cases. This is party time, people. Enjoy it.
So, thank you. With those words, Rachel, do you know prosecutorial discretion, we can't do it by ourselves. So has the Office of Chief Counsel in Maryland, and obviously in other jurisdictions, accepted requests to join in joint motions for PD.
Well, we have a new memo out, new guide out from Melody, and they say that they're going to accept just about everything, and that would be in accordance with the Trisvina memo. And they put out in these 2 pages the sorts of details they would like to see. So yeah, I think that they would definitely be accepting joint motions for just about anything we want, joint motions to reopen for adjustment of status. And if we wanted to go there, we have to be sure to put in the I-485 application, make sure that we address all of the many details that Oakland Baltimore has asked us to. Should we go into those now, or would we like
Well,
to?
John, do you have any thoughts about that?
Yeah, so I think, as Rachel says, we should just go right into this, and let's just dive into it and just go talk about it.
Okay.
Yeah. Okay. So
Go
I'll
ahead,
start.
Rachel.
Thank you. Yeah. So we have their guidance on this, and what they're telling us is, first of all, they'd like us to ask for prosecutorial discretion as early as we can, because they can consider it as early as we make the request with them, and that they'll also try to get around to looking at it for us, even if we don't make the request, and that they would prefer that this request be sent to them by e-service or by email. But we recently heard, I think on Tuesday, that they'll even take it by mail, but if they take it by mail, you better send them a date stamp copy along so that you can get some proof that they received it, because they're not going to be able to automatically generate any receipt for that.
So they are serving us. It seems the ICE e-service may be better in this case, right? Because then we're getting a receipt, and you may not get a response, but at least you have a receipt that you filed it, and they can consider it. So would you prefer to use the email or the ICE e-service?
I would definitely go with the ICE e-service.
And we have a memo included in how you do this in our materials, and all the memos are included in the materials you'll see.
There's a second reason to use ICE e-service as opposed to using email. Well, I mean, first of all, there's no guarantee of getting any acknowledgement via email. In fact, the Office of Chief Counsel has said that there won't be any acknowledgement email. So you're emailing it out there. You have no idea if anyone's looking at that at Office of Chief Counsel, because you don't know if it's been received. Their instructions to us are send a read receipt request, so that there's some kind of auto response in your email program. But they're not going to do anything. But when you send by ICE e-service, you will get an actual email response saying that what you submitted has been received, and you'll get a second response saying that it's been accepted for review. So you've got proof of that. But even beyond that, there's a document size limit with email. Submission by email is limited to 10 megabytes in size total, and that's the message and any attachments. With ICE e-service, each attachment can be up to 50 megabytes. So you've got pretty much unlimited space to include materials with ICE e-service, as opposed to very limited space with email. So I would recommend absolutely using ICE e-service.
And for those of you that need that email, it's e-service registration, one word, .ice.gov. That's what we have, right? So, or ICE e-service at icedhs.gov. So what is one thing that you need? What are the things that you would include in your PD request? Rachel or John?
Well,
I
John,
would say just one thing first. Please make sure to include a signed form EOIR 27 or EOIR 28. I mean, that's just absolutely mandatory. It's mandatory for ICE e-service submissions, according to ICE guidance. It probably should be for email submissions, and it's a common sense thing. You don't want to have to Office of Chief Counsel to try to figure out, are you really the attorney of record on a case or not? So send in that EOIR 27 or 28, depending on whether the case is at the immigration court level or the BIA. That's whether 27 or 28. Rachel?
yeah, absolutely. They won't talk to you otherwise. So first you want to make your case. You want to show them why you qualify for whatever it is you're asking for. And then you want to also make your case by the law. So any applications you might need to give them to show that they can approve this, because they can approve your request because you're asking to go back down to immigration, and you've shown them that you're going to qualify for this relief. That would be very important to include. If you're asking for administrative closure, you're going to want to show them that you qualify under the factors of matter of Vetzian, as well as matter of WYU. And you're going to discuss your positive equities and your negative your negative points. And I know that we all want to discuss that a bit, because that opens up a whole new can of worms for us about how much negative information we would like to give up front on a prosecutorial discretion request that may or may not be granted. And then we've given all of our documents over to our opposition, who may try to use them against our client.
So that we're talking about the aggravating factors. So when we list these aggravating factors, such as, my client served this amount of time, and you're sending in, such as Melody's PD request says all charging documents, all documents relating to those charges and police reports. Once you've submitted those, you've sort of done the government's work for them. And the question is that a good idea ethically? Is it a good idea for your client to submit all of those negative factors, aside from the criminal dispositions and admitting obviously all the charges? What are your thoughts about that, John?
Well, there's this guidance now we have from Melody Brukova, the chief counsel here in Baltimore. And in her guidance, she's listed a lot of evidence that she would like to see people submit for prosecutorial discretion requests. A fair question is, should you submit all of the evidence that you have that's relevant? I think that really all evidence should be submitted that is compelling, if it is directly relevant. So someone, by the way, in chat, I think Naima asked, where is the Brukova guidance? If you don't have it, it's something that I think we've already posted in the document, or it'll be available in the materials that will be posted after our webinar today. But if there's no criminal history in your case, and the applicant has already had biometrics taken, then submitting an FBI fingerprint record might not be necessary. I wouldn't submit documents that don't help your case. As we've all seen other practitioners' cases where they've submitted 20 boilerplate letters from friends and family that are just a couple sentences each. That's just adding fluff to a case. It's not going to help your case. So I think it's got to be relevant, number one, compelling, number two. It's not going to help the case, don't submit it. But there are specific things that I think practitioners must consider very carefully about turning in, things that might be relevant. But this is really important. This is where your professional responsibility absolutely kicks in. this request guide, the prosecutorial request discretion request guide from Melody Brukova, asked for a lot of evidence that you've got to carefully consider before disclosing to the government. Detailed immigration history, including date and manner of entry, any arrests, null pros decisions, expungements, evidence of fraud, prior immigration violations, failure to pay taxes, criminal charging documents, police reports for certain charges that resulted in convictions, and police reports and charging documents for any pending criminal matter. I would be very reluctant to submit any of that unless I was absolutely certain that none of that could be used against my client in any future immigration aspect, be it naturalization down the road, or seeking permanent residence, or leaving the United States and seeking entry again with CBP. In other kinds of immigration cases, with USCIS, they wouldn't ask for that information and they wouldn't be entitled to. And you wouldn't provide it to the immigration court generally, but you have to think very carefully, is any of that going to lead to future prosecution or removal in a different administration with a different president? You know, how quickly we forget what life was like a year ago, where we were defending everything as much as possible. And now the floodgates are open and the Office of Chief Counsel has said, oh, give us all of this countervailing, damaging information against your clients so that we have the whole picture and can really assess the entire case. I wouldn't do it. I would submit only things that I thought could not be harmful to my client. None of this is mandatory. You are in charge of your prosecutorial discretion request. You get to determine what evidence to submit. You don't have to turn in any of this, but you have to balance all of your client's concerns. Your client, by the way, might say to you, I don't care, turn it in, submit everything. I want prosecutorial discretion and I want it now. But your job as the immigration attorney is to guide your client and to say, you know, I know you want the prosecutorial discretion, but that big word in there is discretion, not guarantee. It's not eligibility for a benefit. This is asking for discretion. And if asking for discretion means that you are sacrificing your client's long-term immigration prospects, then you got to think about that carefully as an immigration practitioner about whether you're potentially harming your client. What's our first rule? Are we doctors? Do no harm, right? I mean, that ought to be our first rule too. So I would look at this list in the PD request guide, and I would be really, really careful about turning in anything. And any evidence that you turn in, you've got to ask the one question: could this be used against my client? Could this harm my client in some way? Now, that doesn't mean that you should be dishonest about things, right? Because you want prosecutorial discretion and you want the government to make a fair assessment of your client's case. But you've got to do it in such a way that you're not turning in evidence that's going to get used against you. Since when does the government need a police report for anything? Ever? Failure to pay taxes? Well, I mean, where does that come up except in very limited contexts about, for example, in cancellation of removal, evidence of payment of taxes? They want you to admit all fraud. Well, I mean, really? You know, any arrest, all expungements, all expunge cases. And they want all documents, all police reports for any pending criminal matter. So if your client has a moving violation that's a misdemeanor case, they want the police reports and all the charging documents. That's, to me, going way beyond what is necessary for any kind of normal case. So I know I talked a lot about this, but I really, really want practitioners to be super careful. Just don't turn over the kitchen sink because it's asked for. Use your brain and make your decision in terms of what is safe to turn over.
Yes, and I've noticed that seems to be more of a trend now that the 944 went out. It seems to be more of a trend even in naturalization cases, Now I've noticed, whereas before they never worried about citations at all, now I get asked, well, where's a copy of the citations? Have they paid them? And there's a specific stipulation there that says if they're under 500, they don't even need to declare it, but they are asking for those things now in CIS. So it becomes sort of a feeling that, okay, we'll give you prosecutorial discretion, which by the way, applies to CIS and does apply to EOIR and does apply to the BIA under, the different memos, the King memo for EOIR and BIA and CIS and CBP. So all of these areas, we can ask for prosecutorial discretion, can't we? What are your thoughts? Rachel?
Well, we can certainly ask for prosecutorial discretion in terms of anything that the ICE attorneys have discretion over, such as cases we might have at the BIA or cases we might have at the EOIR, or cases that have a notice to appear that maybe they haven't filed yet. So those are very clear from the memos that I read. I would also, if I may, just address briefly what John was talking about in terms of what we might give over to Baltimore to make them look kindly on our prosecutorial discretion request. I think John is absolutely right. We have to be very careful because, once you give it away, they have it forever and ever. And so you do want to make a determination as to what documents might be very harmful that the government might use against you later, and they would maybe not have obtained on their own, even if available. Also, I would be considering the fact that the overall tenor, the overall general feel of this whole program is we want to do justice. We've just gone back to that, the government's not going to lose by allowing justice to happen and maybe dismissing some cases, and how there's finite resources and we're just all trying to use them in the best possible way. And they really are tracking how the offices are dealing with the prosecutorial discretion requests. And if you're not going to be approved, there's going to be notations and follow-ups about that. So in some ways, even though there's a lot of discretion all around, there is a bit of oversight on how prosecutorial discretion is going to happen. So if anybody feels that they're being asked by Baltimore for just way too much, things that go really beyond the Trezvina memo, that might be a reason for you to consider sort of quietly not providing that additional information. But my general feeling on asking for prosecutorial discretion, what I intend to do is I'm going to give them absolutely everything that does not hurt my client. They want the FBI printout, sure. They're going to get that anyway when they do the fingerprints for the case. So I'm going to give it because that's one check I can say. I gave you the FBI background check. Am I going to give them criminal dispositions? Absolutely. They're going to know about these. We'd have to lie about them later if we didn't disclose them. So we're certainly not going to do that. So they're going to find these things out either because they're going to see them on FBI or we're going to tell them because that's our ethical obligation. So everything I know that they're going to get anyway, I'm going to give them. And then maybe the fact that I haven't given them all those police reports and some of the other things that they're asking for that I just don't think is terribly relevant won't become quite so obvious and so sticking to them, because they're going to say, well, she did give us a lot. And so that's going to be my view about how to handle this.
So I think we're all in agreement on that give them as much as we can, but not what's going to hurt the client. And we have an interesting question that says, if you have the choice of asking for PD to dismiss, or would you ask for admin close, or can you do both? So what would be your thoughts about that, Rachel?
Well, you can definitely ask for dismissal, and you can absolutely ask for administrative closure. So for me, it would come down to what's better for my client. Maybe I'd want administrative closure because maybe with administrative closure, my client continues to get work authorization, which for a lot of my clients, at least, that is a really big deal. Can I get work authorization or can't I? If the case is dismissed and they had some application pending that was giving them work authorization and they don't have anything else they can do right now, maybe admin closure is better. But dismissal is beautiful because if you can get it dismissed and you have something, for example, you can then go ahead and file directly with immigration that will potentially lead to good status for you and your client and get employment authorization. Or if you're going to try to pursue consular processing and you would just like to get out of proceedings entirely, and then of course you could work on your I-601A. So I think I'd have to see exactly what my options were, and also how my client felt. Some clients just feel so good if you can get them out of removal proceedings that sometimes dismissal is the way to go, and the government seems ready to entertain requests for dismissal.
So I wanted to talk to John and see what John's viewpoint about this. And I was just going to break in and give an example that I just got this week from a case, which sort of shocked me. We had asked Judge Kolch for a case to dismiss a case because we got a cancellation that was moved up and we basically had 2 weeks to file it. And there was no way we were going to get it filed by 2 weeks. And the client had a very old I-130 that had been filed like 15 years ago that had been approved based on his father. So we decided to ask for a motion to dismiss. The guy also had a couple of DUIs, one recently, which had caused him to be put in removal. So we figured probably, maybe we should have asked for admin close, but probably, that we weren't going to get anything. And we were going to go forward on this 42B and with very little to no hardship. And shockingly, we got a motion yesterday that said he granted the motion to terminate based on the PD memos and based on, it was a very long memo that we wrote to develop that. So it is possible, it does happen, that the judges will do this. Now, the advantage of dismissing, of course, is you have more time to do other things that maybe you wanted to do without the pressure of having this hearing that could then end badly. But admin closure with Castro Tomb is alive and well now. So what would be your thoughts, John?
By the way, I just want everybody to be aware here that, hang on a second, here we go. Just want to make sure we're in here. Second.
John, your photos disappeared.
Sorry about that. Hang on a second. Here we go. Should be available now. Okay. Danielle, can you see me at this point?
Yes.
Okay, great. So by the way, I want to remind everybody, this is the Maryland State Bar Association's immigration law section. And our section is open to membership for anyone who's a member of the Maryland State Bar, which includes immigration judges, ICE attorneys, other government officials, and hopefully some of them are joining us and listening to us during this presentation. If they have any feedback, please provide it in the chat for us. We're happy to answer questions and engage in this very important dialogue. So that I just want to keep everybody aware that we are certainly cognizant that this is not just practitioners today representing respondents in immigration court. So I think that that's really important to just keep in mind. And if I can just also just add to something that Rachel has brought up, I agree that we should give everything that is helpful to a case. But I think as a practitioner, your job is to decide what should be submitted and what shouldn't be. Look, candor before the tribunal is always an important professional responsibility, and a person should never make a misrepresentation to the Office of Chief Counsel or lie or try to present something that is not the case. But some of the evidence is not mandatory, and it doesn't necessarily serve your case or hurt your case or help your case. And by disclosing things such as submitting criminal dispositions, that's helpful to just disclose those issues if ICE is already going to have access to that to begin with. Of course, for the things that are already disclosed in cases, say that there's a case where evidence has been submitted and now you're seeking prosecutorial discretion, you don't have to resubmit the same evidence that's already been presented in immigration court as an exhibit, and a copy has already been sent to the Office of Chief Counsel. You could simply refer to the fact that those documents have already been provided. If you feel it's necessary to resubmit them, you could, but if you don't want to call extra attention to something, you could simply refer to the fact that there are things that have been submitted in immigration court as evidence.
John, just to go back to, would you file a motion to dismiss or an admin close? And you certainly can't do both together. So you have to do one or the other.
Right.
So,
well, yeah. So you can ask for alternative relief in your prosecutorial discretion request. And in fact, Ms. Brukova in the request guide says, please identify the relief that you're asking for and any relief that you don't want. So if there's something specifically that you don't want, for example, if you want the case dismissed, so you don't want administrative closure, please tell them, I don't want administrative closure. I'm asking for a dismissal. Don't tell me that you'll administratively close it. That's not what my client wants. It's not going to help my client's case. But if there's more than one option that's good for your client, then you can ask for them in the alternative, but please ask for, identify what you prefer. Don't just say, I'll take either A or B. Tell them what you want, and then tell them if they can't do that, this one would be acceptable, and explain why you want one over the other. I think that'll be helpful for them.
I think something. Oh, I'm sorry.
We have a few questions if we can go to these. So it says, can you ask for dismissal for asylum cases when filed with the asylum office? What are your thoughts about that?
Well, I would say that depends. If you have an asylum application you sent to the asylum office, but you're also in immigration court proceedings, then the Office of Chief Counsel has jurisdiction to try to give some kind of relief if your case is in proceedings, or if there's already been a removal order entered and you filed an asylum application with the asylum office, then again, to address the removal order, you could still request a joint motion to reopen. Traditionally, we don't have cases pending both in immigration court and at the asylum office at the same time, but I on occasion have had cases effectively remanded from the immigration court to the asylum office, where the asylum court has not terminated the case. They've just sort of admin closed it or put the case on sort of hold while the asylum office re-adjudicates a case. So as long as you have something that is in immigration court, Office of Chief Counsel can do something. If there's just merely an asylum application at the asylum office and there's been no court proceeding, Office of Chief Counsel has no authority or jurisdiction there. That's a USCIS issue.
So there are no more UAC cases we know in Baltimore. However, this is a question that was asked here, and it says, if you have a UAC case, a child under 10, are they more likely to receive PD? I think, and is there any chance it would be bumped to the case up to the top of the pile? I think the case would not be bumped up to the top of the pile. We know that. But there might be a possibility that the NTA could be prevented from being filed. So are you more likely to receive PD, do you think, Rachel, on a young child?
I think so. It's definitely one of the factors that they've set forth, compelling humanitarian factors, serious health condition, elderly, pregnant, or a minor. So yes, I think the age is very significant. And as we recall, our prior prosecutorial discretion, we used to be able to get them fairly easily for children as well. So yes, I think that they will be.
I tend to be a little bit more Hobbesian and less Voltairean when I look at this whole thing. And I think, you know, what is the reason for the prosecutorial discretion? Is it just goodwill on the part of the government and the Biden administration, or is it more of an attempt to deal with the horrendous backlog and try to figure out a way to deal with that by changing their enforcement priorities?
I
yeah.
actually have a third theory, and my theory is this is data collection. That the government is collecting data that it can use against your client at some point in time to disqualify your client. In fact, maybe to disqualify PD and then to lock up its removal case against your client, or to create something that will bar naturalization in the future. So this sort of harkens back to the old NSEERS program, where the government was involved in data collection, right? They wanted people to just register and turn in information so they could get data on your clients. So all those documents that Brookova has asked for in this guide, that's data collection. That's things that can be used against your client. So maybe it is in part going to reduce the immigration.
John, there's something wrong with your audio.
Sorry about that. I'll be quiet until we can fix it.
No, your audio it's the voice tone. I'm not sure what's there.
I'm gonna leave it and check back in. That helps.
Okay, so
Can I give a counterpoint to that?
yeah, go ahead.
So I think that at least the Trisvina memo really goes out of its way to talk about how they want to bring decency and fair play and justice more.
So totally
prominently
Voltairean
pushed
there.
Yeah, if you look at page 2 of the memo that was put out, in the center, there's a huge paragraph trying to tell the OBLA attorneys about how important it is to, well, they say OBLA attorneys should remain mindful that immigration enforcement obligations do not consist only of initiating and conducting prompt proceedings that lead to removals at any cost. Remember, as has been said, the government wins when justice is done. And so they spend an entire paragraph on this and they drop a footnote. And so they apparently feel very strongly, at least according to this memo, that prosecutorial discretion will help ensure that justice is done for these cases that are in removal proceedings. And when you use that along with what we've already talked about, their crushing caseload and their need to really unclog their dockets and move forward and stop having people in proceedings forever, the two different types of concerns start to come together to a place where everybody might end up in a better situation, because we're going to have justice done and we're going to relieve the caseload from the EOIR. So I don't dismiss anything that John has said. There is always the fear that we're going to give a lot of information and then we'll have some NSEERS program and people will get hauled in to speak with the officers. But I'm gonna at this point take them at their word that this is a new day, a new dawn, a new administration. They're looking to reach out to help. They're asking the OBLA attorneys to look at everything, even if we don't ask, that they should be looking at it for us and reaching out to us. And I've already personally seen that happen. I was in court last week when the government came in and on a cancellation case and stipulated to 3 of the 4 issues. And so, and you've seen it also just now. So I think that they really seem at least to be bringing this forward with goodwill and with the hope that they can move cases along faster.
Yeah, and before the Trump administration, we were getting a lot of joint motions, and Melody Bukeva was very good about that. I do feel, though, that maybe this is a bit of an attempt after 4 years to try to also, in the DHS secretary's memos and intravenous, to convince UPLA, in fact, that they're not losing, that they're winning by, administering justice. So we've lost John. I don't know if he's back on yet, but I wanted to ask him a question that relates to the memo, the Trevino memo, specifically relating to what people are included and which are not, because specifically in the memo, it lists public safety, national security, and border security. So,
Right.
there you
Danielle?
are.
Yeah.
So you want to address
can you hear
that,
me?
John?
Sure. Yeah. Hey, if my voice gets funny, just let me know. Sometimes too much helium, you just never know. So the Trevino memo talks about who's a priority for removal and who's not. And if you're in a non-priority case, yippee, you got the green light to pursue prosecutorial discretion. But there is some ambiguity in the Trevino memo about who is a priority. And so I want to just really briefly touch on the 3 priority categories to give you some things to think about in terms of maybe your client who's a priority still can get prosecutorial discretion. In the first category, which is the national security category, this priority includes people whose apprehension is necessary to protect the national security of the United States. I mean, that's all it says. But footnote 5 of the Trevino memo says that general criminal activity does not amount to a national security threat. So there's supposed to be an evaluation done as to whether the person poses a threat to 1, U.S. sovereignty, 2, territorial integrity. I guess you want to buy Hawaii or something. 3, national interests, or 4, institutions. U.S. sovereignty, territorial integrity, national interests, or institutions. So if the person doesn't pose a threat to any of those, then the person probably does not meet the priority list for being a national security threat to America. Short of being deemed to be a terrorist, very few people should fall into the national security priority category. The border security priority category. This includes people apprehended at the border or a port of entry while attempting to unlawfully enter the U.S. as of November 1 of 2020. The priority also includes people who are not physically present in the U.S. before November 1, 2020. This priority does not include people who are apprehended at any time in the U.S. at a place that's not considered part of the border or a port of entry. Again, if you were apprehended in the U.S. somewhere besides the border or port of entry, you're not a border security priority. It also doesn't include people who attempted to lawfully enter at a port of entry. Only people who attempted to unlawfully enter at a port of entry. So someone who tried to come in with a visa or a boarding foil or something at a port of entry isn't considered to be a border security issue. The priority, by the way, it doesn't indicate whether a person who was physically present in the U.S. before November 1 and then left and then came back later and got apprehended would be considered a priority. We don't know, are those people considered to be people who were not physically present in the U.S. before November 1, 2020? I would argue that they were. The fact that they departed and were apprehended after doesn't remove the fact that they were physically present in the U.S. at some point before November 1, 2020. But that's an ambiguity that is not resolved. The third category, public safety priority, the memo from Trevino creates a requirement that people who are determined to pose a threat to public safety, in addition to having an aggravated felony conviction or a gang-related conviction or adult gang activities. So I think it's important to look at footnote 6 in that memo. It says the use of the word currently when describing the public safety threat. So there has to be a current threat to public safety. And there's a lot of factors that are listed in that footnote that are referred to from the Johnson memo, the Tay Johnson memo, which is also in the materials being supplied with this webinar. And these factors actually mitigate the public safety concern. So again, is there a current public safety threat? And does the person pose that current threat with having had an aggravated felony conviction, gang-related conviction, or adult gang activities. It's not everything under the sun. So Trezvenia really limits who is considered to be a priority. So look at that really carefully before just assuming your client is a priority, is not going to get PD. There's a lot of possibility here based on these very narrow definitions in the Trezvenia memo.
So that means that we have a lot of options here that, you know, all these people who are, like you said, lawfully entered, or people who were apprehended inside the US, those are not enforcement priorities. So those might be then good candidates for a prosecutorial discretion. What are your thoughts?
Yeah, right. I mean, anybody who was physically present in the US before November 1 of 2020, who isn't a border security or public safety threat, they're PD candidates, which is a lot of our clients, maybe most of our clients. Most of our clients didn't first get here after November 1 of last year. So most of your clients are going to be PD candidates. This is very broad. There's a lot of people that are eligible for PD. Most people are going to be eligible for PD. Only a very narrow group is going to find itself to be in the priority categories without exceptions. And even then, in the context of a public safety issue, there has to be an evaluation. Is the person currently a public safety threat? And there's a lot of mitigating factors. So I think you could make the argument pretty much for almost everybody that the person should be entitled to prosecutorial discretion. But read that Trezvenia memo carefully and cite to it if you think, you know what, I have something I want to point out is not a priority case, and explain why. I think that'll really help your PD requests.
So we have about 7 more minutes. So do we have, let's see if we have any questions from anyone that we haven't covered. I've sent the emails for Brukewa. Just another thought. If the NTA obviously has not been filed, so most of us have this issue where people come across the border, the NTA was never served with the court, so the client is not in removal proceedings, but they can't go to the asylum office because they entered across the border. And I recently got an email this week from Ms. Brukewa, who said basically that not to ask them to try to get the NTA filed, especially if it basically wasn't fitting in NISB Chavez. So if the time and place were not there, they weren't going to file it anyway. So at least they're concerned about what kind of prosecutorial discretion you might even be able to get for those people if they're not going to file the NTA because it's defective and they're in limbo because they have no other relief they can ask for. So I think we've unmuted at this point, and if we have any live questions from anyone.
I had a question, Gabriel Vine, that I have placed. What about a case that's sitting with the BIA that is there on an appeal of a continuance that was denied, etc., but it's a very good adjustment of status case? Do you think we can use the PD to actually ask ICE to join us in a motion to vacate and dismiss the BIA?
Yes. I mean, you're allowed to ask for PD at any stage, at any time when the Office of Chief Counsel can do something in a case. And in this case, you can ask the Office of Chief Counsel to join in a motion to remand back to the immigration court. But don't stop there. You can ask the Office of Chief Counsel to also stipulate to certain aspects of your case or to relief. You can ask for everything. So yeah, go right ahead, file it. Don't wait for the BIA to issue its decision. Go get it now.
Just double checking. I felt the same way, but before I approach them? and
Yes.
say, "Here, let's go to the BIA and ask them to vacate and dismiss because my client can adjust by USCIS. I thought I'd get your opinion. Meantime.
Yes. Every BIA case you can ask for PD.
And even if you got denied PD, the memos specify that you can even submit a reconsideration of the PD if your facts change. So it's a win-win.
Right. Oh, hey, that's a really important point. Let's say we actually submit these requests and they get denied, right? So currently, the guidance from Office of Chief Counsel is that if you're a member of AILA, there's supposed to be a liaison with AILA that will assist Office of Chief Counsel in reviewing cases again. That might be you, Danielle. So you might have that job. If you're not an AILA member and you get a denial, reach out to one of us anyway, and we may be able to help you since we liaison with the immigration system.
So I have another question, and Angela just told me that we can go a few minutes over if there's too many questions. So if a client, and this is from Ricardo, if a client EWE'd prior to November 1st, but went to a port of entry seeking asylum, would they still fall under the border security category? John?
So the part of this, it depends on the timing, right? So the border security category refers to people who did this after November 1, 2020. So if a person enters without inspection and then goes to a port of entry, and it's around the time of trying to of the unlawful entry, if it's after November 1, 2020, then that person is considered to be a border security priority. But the person had been here before and then left and came back, physical presence before November 1, 2020, that person is not deemed to be a priority into the border security category. The way that the language works in the Tresvigna memo, it creates this sort of ambiguity involved. So you got to look really carefully at the language of the Tresvigna memo and the facts of your particular case. Even if your client is deemed a priority, doesn't mean you still can't ask for prosecutorial discretion. You just have to look at whether there's mitigating facts that would still grant your client prosecutorial discretion.
That provision is an or provision. Apprehended, yeah, at the border port of entry while attempting unlawful entry, and the other is non-citizens not physically present, and they're both before November 1, 2020. So you have to avoid both of them.
Maybe. I mean, it depends if it's an inclusive or an exclusive or. I might argue my client was physically present and therefore should not be considered to be a border security priority. Let's see what happens. We have no idea right now how broadly this discretion is going to be interpreted. This is the very beginning. No one has even taken the first step in this race yet. So everything is potentially on the table.
Also, what's very important to remember is that these are just presumptions. They're still, as John pointed out, they're still able to grant prosecutorial discretion, even if you fall into a priority. So certainly if you vaguely fall into a priority, there's still a lot of room there to be requesting prosecutorial discretion.
Yeah, this is guidance, but the doctrine, the concept of prosecutorial discretion applies to every single case before the United States government. The US government has the ability to engage in prosecutorial discretion for every single case it has. This is just guidance on what it's deeming to be priorities versus non-priorities. But every case is potentially subject to prosecutorial discretion.
So in one sentence, what are your final recommendations to this Maryland State Bar Group? John, you want to go first?
I'm going to say, have a party because you can do it all.
Guys, if you could please repeat that
Rachel?
email address. It has not been sent out. I don't know where you sent it. I don't see it on the chat. I asked for it like 3 times, please.
Okay, I sent it. I think it's been going to Angela, so I'll send it to you separately, Claudia.
Or
Well,
just
make
into
sure
a
you
chat
get it,
if you just
Claudia.
type it in a chat. And we see it.
So while
Rachel?
Danielle's typing, I would say, wow, just go ahead and do it. This is so great. We have prosecutorial discretion back. We've got great memos to work with. Do it. It really is going to help us.
Thank you both for being so helpful and contributing to our membership here at the Maryland State Bar, and Rachel is in charge for the attorneys. So if you have any questions, you can always address them to her. And if you have other questions that you forgot to ask, you can reach out also, and we'll be happy to address those. And thank you all for attending. We appreciate it. And we hope this has been very helpful to all of you.